Our next topic of discussion is one that I personally find quite interesting, which deals with the question around the legalities associated with the making of inventions by artificial intelligence. Not so much about the ability of artificial intelligence to invent, but I'm sure that will be covered as well. But some of the interesting questions that exist in law around it. Our speaker dealing with this topic is Ramon Pereira. Ramon is a senior associate and a qualified patent attorney in our patent department, and he's got a keen interest in the intersection between commerce and technology. He currently specializes in the management of foreign clients' patent and design portfolios in South Africa, and he has a master's in science and molecular biology from the University of Cape Town, as well as an LLB. Ramon, we look forward to listening to you.
Great. Thanks so much, Peter. Welcome, everyone. So as Peter was saying now, the topic of conversation is robots inventing, and in particular, and their ability to invent. Within this discussion, I'm going to discuss basically two parts of this discussion. The first part is just discussing where we are sort of within artificial intelligence and whether artificial intelligence can be considered to, say, invent something. And then the second part of that is, as Peter was alluding to, is to actually look at the conversation of, if, let's assume that artificial intelligence is able to invent something, though, is our legal system or is the legal system around the world ready for it? Now, what kicked all of this off, there have been sort of conversations about this between patent attorneys for a few years now. It's about artificial intelligence being involved in patents and how exactly that's patentable and where that's patentable. Now, there's a gentleman by the name of Dr. Stephen Thaler, and he basically came up with an artificial intelligence called Davis. Davis is quite a long acronym, but in essence, this is how he describes what Davis is able to do, which is autonomously combine simple concepts into more complex ones that in turn launch a series of memories that express the anticipated consequences of those ideas. This should sound familiar because this is in essence how your prefrontal cortex works in humans. And so in other words, he's positing that there is a certain amount of consciousness or ability for artificial intelligence to autonomously think for itself. Now, as Peter was saying, my background is life sciences, so I'm not a computer engineer, I'm not an electrical engineer, and a lot of the terms are a little bit over my head, but as I understand on the base level, it looks at the neural networks. You have an underlying layer which has a bunch of information in different databases. So for example, you'd have words, pictures, a whole bunch of that in a bottom layer, and layered on top of that might be a few layers, and what they do is then try and make connections with them across those different databases. So if you think, for example, a cat, the word cat, there's also a picture cat, there's different databases that will then forge connections with. And these neural networks, the way that artificial intelligence works is trying to fuse those different connections in the base layer information as well. And where Davis, arguably, I don't know, but Dr. Davis says the way it's different is that then it starts weighting those averages as well on those connections. So in other words, more interesting or more pertinent connections are then strengthened, and ones that are not, are less interesting, are then weakened though. Again, this is very reminiscent of how the human brain works and how we function as well. Some other guidelines, there's actually no real definition of artificial intelligence. It actually popped up in a conference in about 1956, so it's been around for a while, but people in the field define it, some AI as narrow AI, and others refer to other AI as general AI. A narrow AI, for example, is a reactive machine, which has a very limited environment, a very limited narrow environment. So those artificial intelligence which are playing chess and trying to figure out which is the best move, they're looking at just the chessboard as it is immediately, looking at perturbations of it, and then applying the most likely one to score for them. But as soon as the game board's changed again, it's not relying on memories to go back to and think, okay, what did I do in the previous round? And so from that perspective, it's considered quite narrow. You've also got other things called limited memory artificial intelligence, which are what we use for self-driving cars. And then you've got what's more in the general AI side, which is more looking at sort of more broader memory, referencing back to broader memory. And then obviously self-awareness would be the pinnacle of human intelligence, though. Other guidelines, in response to Dr. Thaler launching all of these court cases around the world, your different patent offices have had to really grapple with the concept of can artificial intelligence invent? And within that, then obviously come certain guidelines. So within the EPO in particular, issued guidelines specifically on artificial intelligence. In my opinion, though, they've just completely relegated it to as a tool, and it's more kind of guidelines on how exactly you would use, how exactly you would claim artificial intelligence in a patent. And the way that you would do that would be to have sort of technical effect and purpose. In other words, artificial intelligence has to have some kind of effect which then leads to your outcome and purpose, and then it should be patentable. My thinking on it is that if you think about how a certain an invention is created by a human being, as an electrical engineer, you'll go to university for 9 sometimes longer years. You'll get a lot of sort of base layer information on different things, and then on top of that, you'll eventually then have sort of a worldwide experience. And then the question is you'll become myopically focused on a problem, and then you find a solution within that, and then you've invented something. So is it really a creation, or is it more of a discovery? Are you discovering that information, looking at all the baseline information, or are you creating something out of the ether? And arguably, if it's more leaning towards discovery, I don't see why artificial intelligence can't necessarily invent something. Now, turning to the second half, which is more looking at robots as inventors, the worldwide consensus is basically, it's gone through a number of different court cases, and the worldwide consensus is that robots cannot invent. The reason for that is basically that to invent is human, and one of the reasons, one of the things they focus on is a robot can't at present hold any ownership rights. Our legal systems don't allow for it. There's no personality allowed provided for it. So how exactly would a robot then assign the rights from itself onto, say, the applicant that would then eventually be the holder of the rights of the patent? And on top of that, what most of your court cases will look at is basically that patents are statutory rights. So within that, there have to be reference to the patent. So the court cases they go to the point of saying that as it stands right now, our Patents Act or legal frameworks themselves don't necessarily provide for it. So for example, the most recent case is actually a US case, and that was heard in the federal court, and they basically said that there's reference to individuality, so very much focused on natural persons. But arguably other jurisdictions don't necessarily go as far as saying that, and South African patent system or Patent Act, I don't think necessarily goes that far. And the Australian Patents Act also arguably didn't go that far. So there is one sort of dissenting judgment around the world, which has subsequently been overturned, but I think that the sort of legal reasoning is quite interesting. One of the things they looked at is that they said the word inventor itself implies sort of a natural person, and they've had a lot of reference to O-R-E-R at the very end, implying sort of agency, and so from that perspective is natural person. What this judgment actually said was what words change over time, so that doesn't really definitive, and that's not a good example. For example, a dishwasher has a very different meaning 20, 50, 60 years ago than a dishwasher does today, so it can be used both a mechanical and then also a person as well. And what they raised in this particular judgment as well is that the problem is that if an AI does invent something autonomously, though, who owns that? Is it the person who created the AI? Is it the person who plugs in information to the AI? Where exactly? So and the reason why they're saying that this is an issue is not necessarily for the AI, because they could care less whether they have no concept of ownership. But it's more about other inventors, because people can then start taking advantage or say that they created something when they actually had no right to actually have a claim to that ownership, though. And what one elegant solution, which I thought was amazing, is really interesting, is the concept of how does ownership pass through from an AI, because they admit that an AI can't hold ownership, but then how exactly do you get around that? And they actually relied on a concept from property law, which is also in South African law as well, which is acquisitive ownership, which is basically to say that you have an orchard of trees on a particular land. The person who owns that land automatically owns the trees itself, automatically cede to the owner of the land. But the fruit that is produced from that orchard, who owns that? At the moment of picking, it's no longer attached to the land, so it doesn't necessarily attach to the owner. Also within our law, it doesn't necessarily automatically flow to the person that is the owner of the land. It actually can flow to the person that is managing or tilling the land at that stage as well, though. So acquisitive ownership doesn't necessarily is a possible solution for how the artificial intelligence would actually transfer, would automatically ownership would automatically assign. Now, from my perspective, I then looked at that because South African patent system is actually the only one that currently has a patent on our books where an inventor is recognized as an artificial intelligence. And I thought that was quite interesting. So is our South African legal system able to withstand, or could a similar argument from the Australian case be able to do? So looking at the Patents Act, the word person and him is used often in reference to the inventor, which on the face of it refers to a sort of natural person. So I thought, okay, that's not great. But then if you look at the Patents Act, there's reference to person and him also to applicants as well. An applicant can be a juristic, a non-juristic, can be a foreign entity. It's a very broad scope, and it's not necessarily limited to a natural person. So I don't think that was definitive. And then the question was, does our law allow something similar? So in the Australian case, it refers to derive, so an inventor or an applicant derives the rights from an inventor. Our law uses a different word, which is acquire. Patents Act obviously doesn't really give a definition of what acquire means, but if you have reference, so I found an obscure tax law, which references acquire in particular with reference to orchards and fruit from the land. So in theory, the word acquire can support this as well. And something that I was then grappling with and thinking about was also the concept that when a technology is created, because the whole argument of it's a statutory right, you can actually kind of get around that, because when a technology is created, at that very moment of sort of plucking of that technology from the artificial intelligence, then rights automatically flow, and that's prior to actually filing a patent though. At that point, the technology can either become a trade secret, or you can register a patent, and then you have all the rights that flow from that patent. So the argument that patents are a statutory right, in my mind, was that that's a sort of falsity, because if the ownership flows before the Patents Act isn't actually relevant at that stage. I did then obviously raise this with a colleague of mine, who is a partner at Adams, and then he pointed out that within that there's the ownership can flow from that technology. So when it's not debating that whether ownership can flow automatically by acquisitive ownership. The problem is that patents are something separate, and that at the creation of technology, you actually have a vested right in registering a patent. And it's that vested right that then at the moment as our Patents Act stands cannot necessarily be assigned, because it needs to be assigned from the inventor to an applicant. And so at the moment that vested right would still sit, so even though ownership might move, the vested right to register a patent still sits with the inventor until some action is taken though. So his elegant solution within that as well was actually, if we just redrafted or put an amendment in our Patents Act, something similar to our Copyrights Act, which is looking at automatic vesting of rights, that could be something, a way to solve it, particularly limited to artificial intelligence. Okay, thank you. That is John Robert over.
Ramon, certainly a topic that lends to itself to creative debate and a lot of creative thought as well. Are there any questions on the topic too, Ramon? Fazana.
That's Dr. Stephen Taylor. So he's actually gone on and he's trying to register everywhere in the world. Partly, I think, just to give sort of notoriety to artificial intelligence, so he's trying to push the conversation forward, probably with deep pockets. And then, so that one specifically related to Davis and Dr. Stephen Taylor. But right, within that, so we have a registered patent. It was actually mentioned in the US case, the federal court said fine, it's relevant to us. But arguably the registrar was forced to actually allow the patent to go through. That they couldn't. Registrar, because of the way that our Patents Act is actually to the PCT applications, there were declarations during PCT phase which actually just prohibits the registrar from actually questioning it through a formal filing, which is automatically gone through. So the question is whether it would stand in court, and I just would like to what would arguments be, what kind of arguments would be based on that.
Any further questions? Do you think it's valid, the South African patent?
No. So I think ultimately at the end of the day, I do think that our Patents Act is maybe, and I think that's the clarity between the difference between vesting patent rights, and that you've got to actually think of patent rights separately from ownership rights in the technology. Actually, there's a reason why intellectual property is not a branch of property law strictly per se. So I'm using a property law, in my
Any further questions for Ramon? Thanks, everyone. Thanks, Ramon, for a very interesting talk.